morning, everyone. My name is Rosie Wakeham and I'm Head of Training at HDR UK. Myself and the training team are delighted to introduce the first in a series of 4 interactive webinars delivered in conjunction with Hardian Health on bringing software as medical devices to market. So the first webinar is going to be on intellectual property in healthcare, delivered by Stephen Carter, Hardian's intellectual property consultant. I'll hand over to Stephen in a moment, but a couple of housekeeping points before we start. Firstly, the webinar will be recorded and the recording will be made available after the event. Please feel free to enter questions into the chat, but Stephen will pause at intervals throughout his talks to take questions, and then there will be a dedicated Q&A session at the end of the session as well. So please ensure that your microphone is on mute for the majority unless you're speaking, just to remove background noise. I'll be back at the end just to give you a little bit more information about the next webinars coming up in the series, and also to inform you about some other initiatives going on at the moment being offered by the team at HDR UK and ways that you can stay in touch with what we're doing. So I will hand over to Stephen now to get started, and thanks everyone for joining us today. Off you go, Stephen.
Great. Thanks, Rosie, and good morning, everyone. Great to see lots of you here. So yeah, as Rosie said, I'm Hardian Health's IP consultant. So my background is I'm actually a UK and European qualified patent attorney, but now spend most of my time consulting with startups and small businesses, primarily in the medtech space, helping them with IP strategy more generally. I'm going to get going in a minute. Before I get going, I've just got, I guess, one question and a little bit of audience participation. I'm just interested to know the sorts of people I'm talking to in the room, and particularly what your kind of existing knowledge level is in relation to intellectual property. So if you could just pop in the chat to me, we're going to use a scale of 1 to 5. So if you pop in the chat on the scale of 1 to 5, 1 being you consider yourself a novice in relation to intellectual property, and 5, you consider yourself an expert. Question why you're here, if you think you're an expert, maybe somewhere between 1 and 5. If you could just pop into the chat those numbers and get a sense of the sort of audience I'm talking to. Great. So we got some 1s, we got some 3s, lots of 3s, lots of middle of the road people, some 1s and 2s, 1s and 2s and 3s and 4s. Great. So we've got quite a good mix of knowledge there. No experts, so I can get away with quite a bit today. Right. Let's get on with the show. So hopefully no one's put 0 in there, not that I gave that as an option, but hopefully this isn't your approach to IP. But in my experience, this is an approach that quite a lot of very small businesses take to intellectual property. And hopefully the message that you're going to go away with today is that even as a small startup business, this really is the wrong approach to be taking to intellectual property. And there's a lot that you can be doing with the right mindset, the right IP mindset from day one in your business to make sure that you get the right foundations in place, so that when you come to raise money down the line, when you come to sell your business, when you come to bring product to the market, your IP position is sound and strong. You'll get a big tick in the box from investors. And so why is IP important to businesses in this space? Well, I guess the starting point is that if you're innovating, which I imagine a lot of the people in this room are, either in the academic environment or in a business commercial environment, but if you're innovating, you're creating what I refer to as IP assets, all of that valuable, intangible stuff that the future value of your business is going to be built upon. And typically in businesses these days, in this kind of knowledge age that we live in this digital age that we live in, at least 80% of the value of your business is going to be in these intangible assets, in these IP assets that you're creating as you develop your products, as you develop your services, as you innovate as a business. And if that doesn't convince you that IP isn't important, then it's going to be an important asset for your business. This is a statistic from a study that was done by the European Patent Office and the European Trademark Office about 2 years ago now, based on, as it says there, the observations of over 100,000 businesses. And what they found, they looked at the revenue generation per employee between businesses who owned intellectual property and looked after their intellectual property appropriately, and those who did not own intellectual property rights, so didn't take the steps to protect those IP assets that they were creating. As you can see, overall, the earnings, the revenue per employee was 55% more for all businesses. But if you look at SMEs in particular, the revenue per employee jumped by 68% for businesses who were taking those steps to look after their intellectual property. So with that background, what is it that we're going to cover today? So the main part of today, probably for the next hour or so, maybe slightly longer, is going to be the formal presentation part. So I'm going to talk to you about what I see as the path that you should follow when you're thinking about intellectual property strategy. So we're going to start by talking a little bit about the value in your business, because intellectual property and intellectual property strategy shouldn't exist in isolation. It can't exist in isolation. It really has to be tied intimately with your business ambitions, your business plan. So that's always the starting point if we're thinking about IP strategy. Let's think about where the value is in the business. Once we've identified that value, we're going to go on to look at what are these IP assets that I've referred to, and what are these things that underpin that value in the business that you're creating as you innovate. And then in relation to those IP assets, there's three important pillars of IP strategy that we're going to go on to look at. The first of those is ownership, which sounds obvious, but you'd be surprised how often I've encountered situations where small businesses haven't actually owned the IP assets on which the value of their business is being built. We're going to talk a bit about the risks associated with IP assets, and then we're going to finish with the bit that everyone tends to think about when you refer to intellectual property, but actually for me is really the icing on the cake. And without these other foundational building blocks in place of ownership and dealing with the risks, the protection is really worthless. So we're going to finish by looking at IP protection, the different sorts of protection that are available, and the strategies that you ought to have around putting that protection in place. So as I say, that's probably going to take us through about the first hour. We're going to stop for questions along the way, as Rosie said. So do pop questions into the chat, but also we'll have a chance for you to stick your hand up and ask questions live as well. We'll then probably have a short comfort break, and then we're going to go into a more extended live Q&A session. So to give you the opportunity to ask questions that may not have been answered along the way, or indeed any questions you have about intellectual property and IP strategy more generally. And then, as I think was mentioned in the email that came out ahead of today, what I'd like to try and do is finish with what I've referred to there as a live clinic. And so this is if there's any brave enough participants that are prepared to share with the audience what it is their business is up to, an opportunity to showcase your business, I guess, and just have a chat with me and talk through in the way that I would do as an introductory chat with prospective clients or of Hardian, chat through what your business is about, and we can have a discussion about how IP might apply to that business. I'll remind you of this at the time, but just a word of warning, obviously it's a public forum. Please don't share any commercially sensitive information, and also don't share any technically sensitive information, so stuff that you really want to be keeping under wraps, particularly as this is being recorded and shared more widely afterwards. So that's the outline for today. Let's crack on with the program. So as I say, the first step when you're looking at IP strategy is really to step back and look at your business and say, where is the value in my business? Now that might be, where's the value today? It might be, where am I expecting to create the value? So you want to be looking at how fundamentally, how now or in the future is your business going to generate revenue? Is that going to be through taking a product to market, selling a product? Is it going to be through licensing IP that you're generating, licensing software? So yeah, if you had a bit of paper in front of you, you could probably all sit down now and scribble 2 or 3 examples of how you expect your business to be making money now and in the future. Once you've done that, we need to start thinking about these IP assets that underpin that value in the business. Now, what do I mean by an IP asset? So I've given some examples here, and I think it's really important to make this separation between these underlying assets and then the protection that you can wrap around them that we'll come to later this morning. So if we take a typical medtech innovation, so let's say that you're developing a platform and an app that's going to take readings from your smartwatch, and it's going to give you some information about blood pressure, and it's going to give you some information about heart rate, and it's going to use those to predict the likelihood that you might suffer from some kind of heart disease further downstream. So it's going to do almost like some kind of mini diagnostic process. So the value in that business is going to be generated through sales of your app primarily, and potentially some services that you offer alongside that, but primarily sales of your app. So that's where the value is going to be. But what are the assets that underpin that value? The obvious one is the app or the software underneath the app itself. So that's one of these important IP assets that we're going to be considering. But there's more to it than that. There's the design of the interface in the app. Usability in this space is clearly very important. And one of the things that might set you apart from the competition is the design of the user interface in your app. So again, there's going to be design there. There might be copyright we'll come on to, but there's going to be design is going to be another important asset that underpins that. One of the other assets that might underpin that is know-how. So just if you like, the background research that has gone into defining and designing the algorithms that underpin the service you're going to be delivering. In some cases, they're going to be technical information. So particularly if you're talking about services and products that combine maybe sensors with apps or sensors with a recording platform. There's going to be technical information about how those sensors work, what are they measuring, how are they going to interface and talk to the cloud platform if that's how the system works. Data is another IP asset that's very important in this space. So a lot of value in a business can be captured in the data that's being created through the use of the app in this case. And what you're seeing in some cases, I've worked with a couple of businesses where, if you like, their sort of path to commercialization is they're releasing an early version of the app. They're using that to collect this valuable data. They're then using that data to iterate future versions of their app. And ultimately, their end goal is to have a useful collection of data that itself could be a commercial revenue generator for the business. So data is super important. That's another asset that's going to underpin future value in the business. And then we get to the sort of some of the softer assets. So things like creative work, brand, and commercial information. These are all important assets within your business that need looking after, all important IP assets. And brand in particular, particularly as a business grows and becomes well known for providing a good product or a good service, brand can quite quickly become one of the more valuable and the more important assets, because it becomes not necessarily a technical differentiator between you and the competition, but it's the thing that you are known for. Your reputation is associated with your brand. And if you don't look after your brand appropriately, then you run the risk of that reputation being damaged. So brand is another important asset that builds lots of value in the business. So before we move on to the next section, which we're going to talk about ownership, are there any questions? I'll have a quick look in the chat. Are there any questions about those two sections? So how you go about identifying the value in your business and what these underlying IP assets are. There's nothing in the chat. I don't know if anyone's got any questions. I think you can use the stick your hand up option. Right, I'll take that as a no. So we've taken the step of working out where the value is going to be in our business, and we've identified these underlying IP assets. So, the software code, the user interface design, the brand we're going to operate under. The next step along this IP pathway is we need to think about where the ownership of those assets lies. And ultimately, we want to make sure, as far as we can, that the ownership of those assets is within our business. Because particularly when you come to investment, the potential investors in your business are going to want to know that you've got control of these assets, you've got freedom to exploit these assets, and the best way of putting yourself in that position is to own them. So what are the common problems that I've seen working with businesses in this space in relation to IP ownership? And I guess I should preface this by saying that one of the things I've done quite a lot of in the past is working in the context of corporate transactions of one sort or another. So investments, sales of businesses, and working on the due diligence around the intellectual property of the business in that. And ownership is one of the most common problems that arises, because it's not easy to spot. It's not something that you necessarily identify unless you go looking for it. So in many ways, it's a bit like a ticking time bomb. You have one of these ownership problems that hasn't been uncovered. It's there ticking away in the background. And the one time you don't want it to explode in your face is the time it does, which is when an investor and the investor's lawyers come and start digging in depth into your business and uncover these problems. So one of the problems I guess I encounter most often is this assumption, and it's a reasonable assumption to make, but this assumption that if I've paid for this thing that's being developed, I must own it. And sadly, when it comes to intellectual property, that's not always the case. So if we take the example of software code that's being written for you, and a lot of small businesses collaborate with others. They use contractors, not employees, to write their software code. They might outsource the development of the app to a specialist software house that's qualified to be developing apps in this sort of space. And the default position is that asset you're creating, the software code, will be owned by the person who created it, or their employer if they're employed, so the software house or the contractor. So unless you have the right agreements in place from the outset with these people, you could find yourself in the position downstream where, even though you've handed over a decent chunk of cash to pay them to develop the software, you don't actually own it. So it's really important to look at those terms and conditions with the people you're working with and make sure they have the right provisions in place. Collaboration is an area that's kind of rife with potential ownership problems. I imagine a lot of people on this call have been involved in collaborative projects where you've got some grant funding, and grant funding is often about encouraging collaboration, which is clearly a good thing, and it moves the space forwards. But those collaboration agreements will almost certainly have clauses in about what happens to the intellectual property assets, who owns the assets, who owns the IP that was sort of brought and put into the project in the first place, and what the participants in that collaboration are allowed to do with it, who owns IP that's generated in the course of that collaboration, and what is each participant allowed to do with it. So again, it's one of those really important factors that you have to understand when you're entering into one of these collaborations, and be super cautious and check that if you've got great plans to develop a product based on the results of this collaboration, you need to be certain that that your business will have the freedom to commercialize the output from this project in the way it needs to grow in the way it plans to grow. Founders, why have I put founders there? So this is another example of a problem that I've encountered multiple times, particularly for early stage businesses, where the founders, often a new business is built on the foundations of a great idea that a person has had or a small group of people have had. They see commercial opportunity and they come together and they found a business and start growing it, and they get to raise some seed funding, and maybe no one's paid too much attention to the IP, and then they get to a more significant round of funding and someone digs a bit deeper and they realize that the founders created a lot of the original IP before the company was incorporated. And so what does that mean for ownership? Well, clearly the company can't have owned that IP at the point it was created, because the company didn't exist. So what does that mean? Well, that means the IP still sits with the founder or the founders, or the people that came up with the idea, the concepts in the first place. And that's soluble. You can transfer, we call it a sign in the IPO, but you can transfer the IP into the business. And that's really easily done at the very early stages of a business, because that IP doesn't have a great deal of value. The company doesn't have a great deal of value. But if you leave it until a long way down the line, now, I'm not a tax expert, hold my hands up, I don't really know a great deal about tax in detail. But what I do know is that if this IP has become a very valuable asset and you're transferring that from some individuals into the business, then there could be some significant tax implications there. So again, it's a risk, it's a problem associated with IP ownership, which is very easily soluble if you identify it early and you sort it out. It can be a bigger headache down the line. And then employees can also be issues around employees with IP ownership. Generally, the laws around the world work to say that if an employee creates IP in the context of their employment, then that IP will be owned by the employer. But if you have the right clauses in your employment contracts, then you can avoid that problem. So what approach should we be taking in relation to ownership of IP? And what are the factors that you want to be thinking about? Well, so the first thing we're going to look at is relationships. So what I encourage businesses to do is to early on and on a regular basis, just take some time to think about the relationships your business as an entity has with all of the people and all of the other businesses that it's working with to build this wonderful digital health product or medtech product that's you're going to take to market and change the world and build lots of value in a business. And one way that I try and do this with people if I sit down with them is we build something that I call a relationship map. So we have the business at the center of that map, and we identify all of the players and all of the actors in this play that's going on. So that will include employees, it will include contractors, it will include other businesses that you're partnering with or collaborating with. And so you can map out all of these players, all of these actors in the innovation that's going on. And then you can identify at the same time the roles that they've got. What is their participation in the innovation project? What's your expectation in terms of the IP assets that they're going to be generating? And having understood that, you can then define these relationships between the entities. And then most importantly, the next step is you can look at what agreements, if any, are in place to govern that relationship. And if there aren't any agreements in place, and I noticed there's a question in the chat about this, so we'll come back to that probably with a short Q&A in a minute. But if there aren't any, then that's a warning flag to say, well, look, if there's no agreement, what's the default position going to be in relation to ownership of this IP? And if it's not what we want it to be, and frankly, even if it is what you want it to be, having an agreement in place that governs that relationship and governs the ownership of the IP is really, really crucial. So a lot of this, and this will be a theme going through, I guess a lot of this is just having that base level of knowledge and having the right mindset. And when you're entering into, you're starting a new project up, or you're entering into a new relationship because you've got to a stage in a project where you need to bring in more outside help, or you're taking on more employees. So whenever there's a change in the group of people or entities that are involved in a project, just take that time to think about the relationships, think about the IP assets that are going to be generated, that, you know, as we've mentioned at the outset, really are going to be a large part of the value in your business. And just make sure you've got the right agreements in place with those parties. And the way you can do that and the way you can keep track of that is really through, and again, this will be a theme that you'll see will come out through, is good record keeping. You know, unless you've got a good record of who's involved in the business, what their roles are, and what those relationships are with the business, and preferably in one of these IP relationship maps, then when you do get 2 years down the line, 3 years down the line, 5 years down the line, and there's questions from the legal team of the VC that you're looking to take investment into, or the corporate that you're looking to sell your business to, or other potential collaborators that are asking awkward questions about IP, it's going to be really difficult to go back in time and work out what the situation was, you know, who was doing what, where does that ownership of the IP lie. Whereas if you've got good records, one, it allows you to test and put in place those good agreements that you need, and two, it also allows you to answer those awkward questions that you might face in due diligence downstream. And then the other thing I encourage and again, you'll see this will be a bit of a theme going through, is process. A lot of people, and a lot of you working in this space, you'll be very familiar with process in terms of the regulatory pathway you have to follow, and you'll have really good record keeping in relation to that regulatory pathway. The IP processes can piggyback a lot of the time on that regulatory, or if you have product development, process development, service development processes that you're following, a lot of the time the IP processes can piggyback on those. So the way you implement these steps in your business has to be something that works within the day-to-day operation of your firm. What I've seen many times is people set out with good intentions to make sure that they're looking after their IP assets properly. They're identifying when they're being created. They've mapped out what those relationships are. And then all of that good stuff gets put to one side because it doesn't fit with business as usual, and it gets forgotten about until someone, say, comes knocking and digging. So one of the things that we'll do if we're working with a Hardian client in relation to this is we'll help them weave this IP thinking, this IP mindset, and these steps that you want to take to be looking after your IP, weave it into the other processes that they have already got set up or that they are setting up within their business. So it just becomes part of the business as usual operation. So we don't have time, too bad. So next topic is risk. Before we move on to that, I've seen there's a couple of questions in the chat, so I will just pick up on that. In fact, they're both, it's from Ashley. Thank you for your question, Ashley. So the question is, for the benefit of others, if you haven't seen it, what if you collaborate without a collaboration agreement? And for example, the difference between working with customer versus collaborators to iterate on an early prototype. So the simple answer is that if you collaborate without an agreement, then when it comes to who owns the IP, you fall back on what the law says. So what the Patents Act says about who owns inventions, what the copyright law says about who owns copyright works, and so on. And one of the difficulties there is that there's not necessarily uniformity around the world in relation to these different rights. So the ownership rules are different for different types of intellectual property assets, and they're also different in different countries around the world. But if we took the UK, for example, if you were collaborating with other businesses with no agreement in place, then the default position would be that each business would own the inventive contribution of each of its own employees. So you end up with a situation where the ownership of the IP is split between the parties, and each party can control their own IP. And if actually you need all of that IP, let's say there's 3 collaborators and you need the IP from all of the 3 collaborators in order to advance the project, then you're in a position where one of those collaborators could potentially act as a block. You know, they could hold the project back. So again, it's really just a case of having that agreement. I mean, and there's lots of good reasons for having an agreement in place between collaborators, beyond the IP side of things, but IP is one of the really important reasons. In terms of working and iterating on early prototypes with clients, again, having an agreement in place can be important. If the customer's involvement is, if you like, testing and providing feedback, then probably there's no new IP asset being created there. If that involves collection of data, then you want to make sure you've got the right agreement in place that allows you to collect that data from the customer and use it in the way you need to use it to then further develop and build your product. So that's really important, and especially if that's any kind of personal data, because then those magic letters GDPR come into play, and it's really important you look after their data in an appropriate way, and you can demonstrate that if you need to in the future. If the collaboration with the customer goes beyond that, and it's brainstorming sessions about how the user interface might be improved, it's brainstorming sessions about what additional functionality you might want and how that could be implemented within the app, let's say, then you're running into a situation where potentially that customer is creating some of the IP assets, or they're contributing to the creation of some of these IP assets. And the risk there is that if there isn't an appropriate agreement in place with this kind of test cohort, you could find yourself in a position where at some point in the future, and again, typically, as I say, these are ticking time bombs. What normally happens is no one thinks about it at the time, and then you get super successful, and these people that then think they've made some kind of important contribution to your product pop out of the woodwork and say, actually, I own a piece of that. You've got to pay me some money. So having that agreement in place avoids those kind of issues. What else have we got? So there's one more question here, which I will address, and then we'll move on, conscious of time. So the question, so this is from Keith. Thanks, Keith. While a bespoke consultation on IP issues is clearly the best way forward, are there any boilerplate agreements out there that can be used as a foundation? He says, I expect I'll point out the risks of this approach. So there are boilerplate agreements, and as Keith guesses, picking the right boilerplate can be a skill in itself. But what there are, particularly for collaborations, and particularly for collaborations where there are universities involved, often the starting point for those agreements and those collaborations is a set of agreements called the Lambert agreements. So these were developed a number of years ago now as kind of best practice in this academic commercial collaboration space. So yes, there are templates, and there is boilerplate that you can make use of. And I think the best compromise, and actually the way that I would always suggest people work, is start with an appropriate template and boilerplate, but then still think through, is it actually giving me the rights I need to use the IP that's being generated, and does it is it unfair, is it making me disclose information that I really don't want to be disclosing? So particularly when you're working with academics in the academic environment, clearly that there's a need for them to publish, and so the agreements will address what can be published, what can't be published, whether there's potential, the ability to delay publication so you can file patent applications, which we'll get onto. But so yes, start with a template, but a templated agreement out of the box is in most cases better than no agreement, but having at least a pair of eyes look over it, whether that's someone within your business or outside, and just thinking through these questions is really important. Okay, so let's move on to risk. Not me in that picture, the sort of thing my son might choose to do, but not me. So what are the risks? So when we think about intellectual property risk, and when I start talking to people in intellectual property risk, the first thing they think about, and an important element of it, is competitor IP. So are there any nasty competitors out there that have intellectual property rights? So whether that's patents or copyright or trademarks, that my innovation, my product might infringe when I launch it to the marketplace. And that's a potentially serious issue, because if you launch product onto the marketplace that's infringing someone else's IP, then worst case scenario, they can stop you in your tracks. So they can get an injunction from a court that just says, can't do that, you've got to stop right there. They can force you to take a license, so your bottom line is hit by that. All of a sudden you may not have a commercial proposition if you're having to pay a license fee. They can claim financial compensation for any sales you have made, and particularly if they can show that you've done damage to them, or they can just say, we'll have a share of your profits, please. So there's all these downstream consequences of infringing competitor IP. Now it's a minefield. When you look at the patent space in particular, and we'll come on to talk about patents in a minute, but when you look at the patent space, there's a big field of patents out there. There's lots of patents, and it's extremely expensive to analyze that space in lots of detail. So when you're thinking about how do I deal with competitor IP, you have to think about, I like people to think about it a bit like an insurance policy. So if you're about to invest 2 million quid in developing a new product, or the next stage of development of the product, then it's worth spending a few thousand or maybe £10,000 on some patent searching to try and be as certain as you can within that budget that you're not going to be infringing someone's patent. If you're at the very early stages, you probably don't want to be investing £10,000 or £20,000 in a patent freedom to operate exercise, because you've got lots of other things that it's more important to spend that money on. And the risk is lower because you're further away from market, you're not close to launch. But doing some initial patent investigation at that stage can still be useful, because it can give you a sense of who else is busy in this field, at least from a patent perspective. It sometimes can even give you kind of inspiration about ideas that you might adopt and change enough that you're not going to be infringing patents. And also, when you conduct patent searches, yes, some of the things you find in that search might be granted patents, but a lot of them will be older patents that have expired, or there'll be patent applications that have not been pursued through to grant. And all of that is freely available information that you can actually legitimately use to advance your own thinking and your own innovation. So there's a lot of reasons to do some relatively inexpensive, if you like, quick and dirty patent searching, even right at the outset of a project. And you might even find potential collaborators that way. So you find someone that's active in this patent space, another small business, and maybe there's a partnership that can be formed there. So that's competitor IP. So it's a problem, but it's one you need to be aware of, and it's one that you need to come up with strategies to address, but clearly strategies that are achievable within the budgets you have at the different growth stages of your business. Broken relationships is another risk, and the other two I've put there is IP leaks. So broken relationships and IP leaks sort of go together. So these are, if you like, people or relationship related issues, and they're more what I would call internal risks rather than competitor IP, which is an external risk. So what do I mean by broken relationships? Well, I mean agreements or relationships that aren't governed by the appropriate agreement, as we've just been talking about. The other one I've seen several times is relationships where the agreements have not kept up with the evolution of that relationship. So very often, you're entering into a discussion with a new potential partner, you send them your standard NDA, which they sign up to, and the standard NDA obviously obliges them to keep the discussions confidential, and it probably says something along the lines that this doesn't represent a license of any IP, each party still owns all of their IP. All well and good, have those initial discussions. You then go on and you like this partner and you say, right, yeah, let's work together, let's do something. And then in the back of your head, you're thinking, oh, that's right, we've got an agreement in place now. That's fine, we don't need to think about agreements, we've got one there. But actually that agreement says nothing about who's going to own and who's going to be able to do what with the intellectual property that comes out of that partnering, that work together. And again, you find yourself with the ownership issues that we talked about previously. And then the other flavor of that risk that, again, I've encountered more than once is when you sign the agreement and the agreement is for a 2-year collaboration, and no one's tracking and no one thinks to look back at that date. And so you get into the 3rd year of collaboration and you assume the agreement's still in place and everything's trundling along happily, and actually you potentially put yourself back in a position where there is no agreement, and you're back with all the ownership issues that we discussed previously. And then the final one there, again, is a fairly common misunderstanding, which is that if you secure your own patent, that means you have freedom to commercially exploit your product, your invention that you claimed in that patent. And that's not the case, because patents are negative rights. So what do I mean by that? Well, I mean, they give you, if you get a patent granted, it gives you the ability to stop other people doing the thing that you claim as your invention in the patent. Trademarks are the same. If you have a trademark registration, then you can prevent other people from using a brand that's too similar to your brand. And the same with the registered design. So that's for protection, a registered form of protection for design. So we'll talk a bit more about later, but they allow you to stop other people. What they don't do, they're not a permissive right. They don't give you permission to do that thing. And it's a difficult concept sometimes to get your head around, but I like to illustrate it with a simple example, which is, if I came up with the bright idea, pun intended, of the light bulb, and I get a patent for my light bulb, then I can stop anyone else selling light bulbs. If my competitor down the road then comes up with the idea of a lamp that includes a light bulb and a stand for the light bulb and a shade for shading the light bulb, that's an innovation beyond what I've got, just the light bulb, and he gets his own patent for that. Now I can't sell lamps with shades and stands and light bulbs without infringing her patent, but she also can't sell her lamps with a light bulb without infringing my patent. So the fact that she's got her own patent for the lamp doesn't give her permission to sell something that incorporates my patented light bulbs. And so, in that scenario, we'd hopefully get on, we'd be friends, and I'd license my light bulb innovation to her lamp business, and we'd all carry on quite happily. But hopefully illustrates how having a patent isn't permissive. It doesn't mean that you are necessarily okay to launch your own product. You could still infringe someone else's patents. So what do we do about this? Well, I think that the most important thing you can do as a business is to recognize that these risks exist. Too many people, sometimes when I'm talking about this stuff, I use that head buried in the sand slide that I used at the beginning, because I think some small businesses will bury their head in the sand in relation to IP generally. A lot more small businesses will bury their head in the sand in relation to IP risk, and just assume it's not, well, just don't want to think about it, I guess. But I think it's far better to face those risks head on, because the earlier you identify them, you can track them, you can monitor them, and you can come up with plans to avoid or minimize those risks. So the first step is recognizing those risks. The next step beyond that is about good record keeping. So if you identify a risk, what do you do about it? Well, keep a record of them. I mean, so a lot of you will be familiar with the idea of a risk register generally for a business. There's also a concept called the IP risk register. So a very specifically list of IP risks that have been identified. Because clearly, if you're not keeping track of them, you can't work out systematically how you're going to mitigate those risks. What can be done about them? Is it a serious risk for the business that needs to be discussed by the board? And does it need a change in direction or a change in design of the product? Or is it something that you can live with for the meantime? And then take steps to mitigate those risks. So clearly the steps you take to mitigate the risks will depend very much on what the risk is. If the risks are around those ownership issues, then the solution is often to negotiate the appropriate agreement or put the right terms in place in your employment contracts. If the risk is around competitor IP, sometimes it's just a case of monitoring that competitor IP, because it might still be a pending patent application, for example, and it might be that it ceases to be a risk because either the application isn't pursued to grant, or they amend the protection they're seeking in a way that means it's no longer relevant for you. Another way of mitigating those sort of risks might be that you steer the design of your product around the protection they've got. And a final form or way of mitigating those sort of risks is you can look at the question of whether those, we'll use patents as an example still, whether those patent rights that are being secured are actually valid, or can the validity be challenged. And that doesn't mean to say if you think the validity can be challenged, you have to go to the steps of actually challenging, but you can have that argument, that position in your back pocket, and in your risk register, that that's the mitigation that's available. And if someone, if they do come knocking on your door at some point in the future, you've got the ammunition to throw back at them, or the shield to hold up to them. If the risks are around, so I didn't really touch so much on IP leaks. What I mean by IP leaks is where, for example, there's a risk that if something is put into the public, information is put into the public domain before you file a patent application, you effectively shoot yourself in the foot, because you can no longer validly secure patent protection for something that was in the public domain before your patent application was filed, whether you put it there or someone else has put it there. So again, the mitigation of that, if you identify that's a potential risk, is the right education for employees, having the right terms in agreements, having the right internal processes for looking after that secret information until it's appropriate to release it to the public. So that was risk. I don't think we've had any questions on that, but I'll give you 30 seconds while I take a sip of water to either raise your hand or put a question in the chat if there's any questions around IP risk. Keith has put his hand up.
Yeah, hi, Stephen. I thought I'd mix it up by actually speaking instead of
Yeah. Nice to hear someone's voice other than mine, I think.
Thank you so much. This is really fascinating stuff. Got another template question, I'm afraid. And just to preface it, understanding that, again, what I said earlier on, that it makes sense to speak to a specialist such as yourself on this, but I have some background in clinical safety work and risk management. And so when I heard you talking about the risk register for IP and so on, it sounds sort of familiar. So again, if you're dealing with a very small or very early stage startup that's maybe not quite at the point of doing something so formally, are there templates for the kind of IP risk register or risk management that could be done, on a small scale again? Like I said, sorry, I'm going to be asking loads of questions to try.
No, it's fine. It's always a kind of nice to say to hear someone else's voice. So I guess, yes, I mean, if you're already familiar with working with risk registers, it's really just another risk that could be recorded in a register you're already running. And it's really just about, particularly in the early stage, it's about just capturing the risks so that at an appropriate time, you can go back and look at them and think, understand what you can do about them. So I guess, where the skill or where the skill gap might be is in two places. One, recognizing that something's a risk in the first place, but with a little bit of education like these sort of sessions, you can probably fill that gap. So it's just understanding that. Well, I guess a simple example would be you're developing a product. Word on the street is that another company is developing something similar. So that could already be flagged in an IP risk register as a potential risk. There's another company working in a similar field. There's a risk that they could be filing for patent protection. That's kind of a risk. Going a step further, you might do some basic patent searches, which anyone can do with Google Patents, or there's a couple of other freely available databases. You might identify they have got a pending application or even a granted patent. So that goes in the risk register as something that needs to be thought about when there's time and budget to think about it, but also not too late, because if you get too far down the stream and you're too committed to a particular development path, but there is actually a serious patent risk in the way, then that's the sort of thing. And I keep going back to kind of investors as the litmus test, but that's the sort of thing that an investor, a well-advised investor anyway, would look at and go, well, actually, I'm not going to put my money in that business. I'm going to put it somewhere else because there's a lower risk option for me over there, and there's always choice about where your money goes, isn't there?
That's great. Thank you very much, Stephen. Like, I already feel enormously further forward than I would have been, and I absolutely accept, even with this little information, not going to recognize some of those risks or miscategorize the degree of harm that might come from them manifesting. So thank you.
You're welcome. Oh, Hugh has a question.
Hi, Stephen. My question is related to regulatory and IP risk. If someone declares that they are substantially equivalent to another device that's already on market, is that an IP risk? Because they're publicly declaring they're the same as somebody else. So in my mind, that would mean that they couldn't say that they are significantly different and therefore protectable. But what do you think?
Yeah, I think it's right. It's something we talked about a little bit in the past, but it's true. I mean, there's always an argument, or rather, the onus is very typically on the holder of the patent, the holder of the rights, to prove, ultimately, if it goes to court, to prove to the satisfaction of the court that you are producing something that falls within the scope of their patent protection. Now, clearly, if you've stated publicly that what you're doing is the same or very similar, or certainly sufficiently similar from a regulatory perspective that you can piggyback on their regulatory approval, then that's evidence that a court would take into account. So it means you're starting on the back foot, certainly. Now, it's not an open and shut case, because there could be differences at a technical level of detail that are relevant to the question of patent infringement that aren't relevant to that regulatory question. It could be that patent protection. But I guess it's an example of where you might want to go further in your kind of risk analysis, because you might want to be looking at the validity of their patent in that situation, because there's a higher risk that you're going to be found to infringe, so fall within the scope of their granted rights. So you need to be looking at the other ways of potentially mitigating that risk, which is either looking at the validity of the rights, or potentially having a conversation with these people and seeing whether there's any opportunity for licensing, and I guess also thinking about the markets that you're actually going to exploit in. Is there an opportunity for you both commercially to coexist in a way that's a win-win? But yeah, so yeah, you're right. Okay, and there's a comment rather than a question from Mike, so I'll let you read that, and hopefully it's of interest. Right, protection. So this I guess just reiterating one of the points I made earlier, which is this distinction between the underlying IP assets. So this is the stuff, the things that underpin the value in the business that you're building, or the business you have, as distinct from the IP rights, which are the legal protection that you can wrap around these IP assets, to try and, as best you can, protect the value in those assets and therefore protect the future value in your business. So what are these IP rights? So I'll just step around these quickly so we can sort of understand. And there's two general categories of intellectual property rights that we can talk about, and they are what are generally referred to as registered rights, which are patents, trademarks or registered trademarks, and registered designs. Now they're monopoly rights, in the sense that once you have them, once you've secured them, someone infringes these rights, irrespective of whether they knew the rights existed, irrespective of whether they knew what you were doing or had any insights into what you were doing. So there's no requirement for there to be any copying. So they're monopoly rights in that sense. So if someone produces a product that falls within the scope of your patent in a territory that you have your patent protection in, then they infringe your patent, full stop. Now, if they were unaware of your rights, there might be some wiggle room for them to say, well, I don't have to pay as much in terms of compensation as I might otherwise have done. But fundamentally, they're a monopoly right. If you manage to secure them, then anyone that produces product that falls within the scope of those rights, or a brand that falls within the scope of your trademark rights, will infringe those rights. The flip side of that is that there is an application process that you have to go through for each of these rights, and there are legal tests to determine whether those rights are valid or not. So there's cost involved, there's important timing issues. So probably the most important one to know about is that for patents, as I've mentioned previously, you have to have filed your patent application before there is any public disclosure of your invention that you're going to be claiming in the patent. So that means you have to be, particularly if you're doing product testing, you either want to have filed your patent application before you start testing product, or you want to make sure that you've got very strict confidentiality agreements in place with the people that are testing that, or you're just doing internal testing behind closed doors. There are, in case there's any bright spots on the call that know about a bit more about some of this stuff, there are some countries where you get a bit of a grace period for your own disclosure. So if something inadvertently gets put into the public domain, there's a 12-month, for example, in the United States, there's a 12-month grace period. So as long as you file your patent application in the US within 12 months of your own disclosure, you can still get valid patent protection. But in most places around the world, and the UK, and in fact the whole of Europe, an example of this, if you file your patent application the day after you publish information about your invention, then you're done for. Your patent will not be valid. So that's super critical. And again, having the right invention capture processes in your business, which that sounds sort of grandiose, but it might be something as simple as you have a monthly meeting which might just be your general project catch-up meeting, and one of the agenda items is what's the new innovation? Is it something we want to consider patenting or not? And so it can be, it can be as simple as that in terms of process, but you just want to have that process there. The other forms of protection are unregistered, in the sense that they come into existence automatically. There's no process, there's no legal process for securing those rights. But it also means that it's even more important that you keep good records of what you're doing, when you're doing it, who's doing it, so that you can identify that these rights have come into existence, and then potentially enforce them down the line. So if we just run around, probably the most significant, and the one actually that there's been an increased focus on and a lot more litigation on in the last 3 or 4 years, is trade secrets. And partly that's because the legislation has changed, so that the law has changed in the US and the UK in the last 5 or so years in relation to trade secrets. And it's not, some would argue it's not an IP right. I think it's really important to consider it as part of one of these, the intellectual property spectrum. But a trade secret is what it says on the tin. It's something, it's some information that is secret, and it has value to your business because it's secret. And this is some of the changes that have come into the legislation. If you want to enforce your trade secret against someone who has stolen it, you have to be able to demonstrate that you were looking after your trade secret in an appropriate way. So typically that means demonstrating that you've got the right confidentiality clauses in agreements with employees and with other people you're working with, but also ideally that you're looking after those trade secrets technically in the right way as well. So distinguishing on your servers between those real crown jewel trade secrets and the rest of the business information that's on your server. So having separate secured folders for those trade secrets. So yeah, it might be the algorithm that's at the heart of your, or the algorithms that are at the heart of your digital health platform, that you're not sharing with people, you're choosing to hold back, and you've not been obliged to share them through the regulatory process. So you can genuinely keep them as secrets under the bonnet that if someone else were able to get hold of, would give them a leg up in terms of competition with you. So that's trade secrets, which I say is all around good record keeping, good agreements. Copyright comes into existence automatically. A lot of people are familiar with copyright. They come across it in context of music and art and books. But it also has particular relevance in this space because copyright is the legal protection that you get for software code. So when software is created, when you write code, when you put code down, that copyright protection will come into existence automatically. And if someone copies your code, you can enforce your copyright against them, but only if you can demonstrate that you're the original owner of that copyright, and that it was actually original code and it wasn't taken from a library. Database rights, again, I think is super important, or can be important in this space. They're a right that's quite peculiar to the UK and Europe, but there are specific rights that protect collections of data against people taking chunks of that data in an unauthorized fashion. So if you've got a database as part of your offering and users can access that data, if you've got the right agreements in place, database rights will be one of the things that allow you to, as well as the kind of contractually, they'll be one of the things that allow you to control access to that data, make sure that people aren't using it, or at least have rights you can enforce against them if they're using that data in a way that you haven't given them permission to use it. So again, come into existence automatically. You don't have to, there's no application process, there's no fee, there's no register, which is clearly a positive thing because it's something that doesn't cost you lots of money to secure, but it means the onus is on you to have those records to demonstrate that it was your database and it was your data, and prove that someone copied it down the line. Passing off is probably a term that lots of people are familiar with. It's the sort of unregistered version of trademark protection. So if someone is copying elements of your brand and either doing your business reputation damage as a result, or getting sort of fair advantage themselves because they're piggybacking on your coattails to give the impression to the public that they're somehow associated with you, or even that they're kind of part of your business to get commercial advantage, then there's action you can take even if you don't have registered trademarks. And then unregistered designs is a copyright type right that can protect designs of physical product. And the only thing I'd say there, particularly in relation to trademarks and registered designs, they are registered trademarks and registered designs are a relatively inexpensive form of registered protection. And if you have a registered design or registered trademark, it's much easier to enforce those rights and much less costly to enforce those rights if you're than it is to enforce unregistered trademarks in a passing off action or unregistered designs. So if brand and design are relevant to the value in your business, they're certainly something that's worth considering, and they're often overlooked, but they definitely should be on the agenda of things to consider. And then the other thing I put at the bottom there is agreements, which clearly strictly aren't a form of intellectual property right protection. But as you'll have gathered as we've gone through this presentation, agreements really are key, one of the most important forms of protection in the broader sense that you can have for your business, and having the right agreements. And again, it doesn't have to be costly, complex, expensive agreements, but just having the right agreements, and ultimately having an email exchange between the parties isn't a formal agreement, but if you've got an email exchange that sets out what's going to happen to the IP, who's going to be able to do what with it, that is way better than having nothing and have not thought about and addressed that IP ownership question, for example. So before we kind of move on to talk about what the kind of processes, what are the steps you ought to have in place when you're thinking about protection, I thought I'd take a little sidestep here and just one of the questions that I'm often asked is kind of, well, how relevant are patents to this space, particularly digital health space? So I thought I've got a few slides here that touch on that. And I guess the first thing is, so this is data on European patent filings. US tends to kind of mirror this fairly closely. They're the two typically biggest jurisdictions that we pay attention to. And just to dispel one other misconception, so a European patent is a single application process, and it gets you patent protection in it's about 30, potentially 30 countries these days, and it isn't the EU. So the UK, for example, is still part of the European patent system. So if you file a European patent, you can get protection in the UK through that route, and it's not tied to the EU. And what we've seen, so this is the data from 2021, which is the most recently available data, and you'll see there that digital communication was the biggest kind of technology classification in terms of the number of filings of patent applications, or European patent applications. Medical technology was number 2, and just to be clear, medical technology is, it's devices, it's digital health stuff. It's not pharma and biotech, because you'll see that they've got separate categories, ranked 7 and 8 there for pharma and biotech patents. So this is what I would class as med tech. So it's device, it's digital health, it's those kind of technology innovations. And actually, interestingly, computer technology is the next one on the list. But when you think about a lot of what the innovation is in the digital health space, a lot of that is going to be about digital communication and medical technology, and those are the 2 biggest categories, and actually have been for the last few years. So I think you look at the 2020 figures, it was actually flipped the other way around. So medical technology was the biggest sector for European patent filings, and digital communication was number 2. Ooh, oh, spoiler there. So, and one of the other things I get asked about a lot in this space is patents for algorithms, because there's, well, you see it there, there's this myth out there that you can't patent software, which, yeah, I'm here to tell you is wrong. So I tell people that, and then the next thing is, but okay, but surely, you know, you can't actually patent an algorithm, and actually that's, well, I put there wrong-ish, because the answer actually is, well, one, you can patent software, and there's lots of examples of granted software patents in Europe and the US and elsewhere in the world, but also you can patent an algorithm so long as what you are claiming as your invention in the patent is a practical, or in the terms of the patent law, a technical application of that algorithm. So you can't get patent protection, it's true, just for the bare algorithm, but you can get patent protection for I don't know, a diagnostic method potentially. There's other issues there, but potentially steps towards diagnosis using the algorithm, or a system that's running using the algorithm. So yeah, there's lots around image recognition, for example. So in the radiology space, there's lots of patents granted in that space, where the innovation is fundamentally a new algorithm that gives a better practical technical end result. And these are just, I mean, so these are all US patent examples of fairly recently, you know, sort of from 2021 granted. So these are all granted patents in force in the States right now. So you can see, and they cover things like straight diagnosis based on, so that's using an AI method for straight diagnosis, contact tracing. So clearly that was something born out of the COVID era, I imagine. Telemedicine is another area where there's quite a lot of innovation and a lot of patents. Orthodontic treatment planning, and then kind of other diagnoses around severity of cancers. And that's there, I guess, the ones I'd say are kind of more towards the edges of what's patentable. There's lots of patents in terms of looking at, you know, looking and analyzing images, and that's a kind of classic area where patents have been granted for analyzing images for at least the last 20 years. So it's not like a new innovation there. So we're kind of coming back to the process of protection now, and what should your approach be around protecting? And what are the problems I encounter most often in this area? We'll see them listed there. So the one which I guess I've touched on already is too late. So for patents in particular, you can just be too late to get protection, either because you or another person has put that information into the public domain, or because another person has got to the patent office first. So with the registered rights, patents, trademarks, and registered designs, it's a first come, first served system. So you don't want to go too early, because that's committing you to a level of expenditure over the coming years. But you also don't want to be too late, because you don't want to be beaten to it. So particularly if you're working in a competitive field, you ought to be thinking about patent filings and building into your financing rounds budget for patent filings sooner rather than later. Wrong focus is another one I come across quite a bit. So what do I mean by that? That's where, and again, I'm going to use patents as an example, because patents tend to require the bigger investment. So there's bigger decisions to be made, commercial decisions to be made about whether or not patent filing is worthwhile. And what I see kind of all too often is those decisions are being based on the wrong reasons. They're being based on like how cool, often they've been based on how cool the technology is, how cool the innovation is, how likely you are to be able to get a patent. And yes, the likelihood of being able to get a patent is one of the factors, but the much bigger factor in the starting point, which will come as no surprise, having listened to me go on for the last hour and a bit now, the starting point should always be, what's the potential benefit to the business? Is this patent going to protect a potential revenue stream? Is this patent going to be a potential source of license income? Is it, and this is one reason why some small businesses will file patent applications. Is it something that's going to cover a product that means we can jump into what's called the patent box? Now, the patent box, very high level, is a corporation tax incentive that we have in the UK. That it's all about encouraging UK-based innovation. So if you're innovating in the UK and you secure a granted patent, and you start making profit from products that are covered by that granted patent, then headline basically is you can pay a discounted rate of corporation tax, so 10% corporation tax on those profits that are generated from the patented product, rather than the 19% it is now and the 20 whatever it is it's going up to soon. So quite a significant tax incentive. Clearly it's only relevant if you're making profit, but yeah, I'd hope that most businesses anticipate making profit at some point in the future. So having those patents in place can give you that tax benefit as well. So another reason to think about it. Insufficient ROI. So again, that really sort of is very similar to that previous point. A lot of people are turned off the idea of patents because they've wasted a lot of money on patent or other IP protection, and they don't feel they're getting the return. But typically that's a symptom of not having the right focus for that decision making about whether or not you file a patent or not, rather than it being an issue in itself. And then IP leaks. So you might quite legitimately take the view that you want that you're not in a position to file a patent application at the minute, either because you don't have budget or because there's more development to be done. But if that is the case, and if you want to preserve the opportunity of filing for patent protection, then for all the reasons we've discussed previously, it's critical that you keep that innovation under wraps and secret until either you file the patent application or you've made the commercial decision that this isn't something you're going to get patent protection for and you're happy to put it in the public domain without protection. So avoiding those IP leaks. And again, as I mentioned previously, that's about, a lot of it's about education for the people working with you, and it's about having the right agreements in place. So no apologies for pulling out almost the same slide as previously, because again, as I said, this is a theme that's running through. A lot of it is about record keeping. So I encourage businesses to have what I refer to as an IP asset register. And again, this is something that, you know, maybe in your monthly project meetings or other suitable cadence, one of the agenda items is, right, what work's gone on, what's the new stuff that we've developed, and let's just capture that. So it might be, the next segment of the code's been written, so let's make sure we just got a record that that's been written. It might be that there's been some work on the GUI, so let's record the fact that's happened. It might be that the marketing team have just come up with the name we're going to launch the product under, so that's a brand asset, so we're going to record that. So just having, again, good records is, if you like, the foundation for a lot of this IP stuff. And similarly, as we've talked about previously, having good process and good process that is interwoven with your business as usual process. So whatever you're currently doing, try not to have IP as a kind of separate thing, and weave this IP thinking into your existing processes. So, and then before we move on to IP strategy, which actually won't take us very long, have we got any questions about IP protection. So Zoe asked, do you have any recommendations for digital record keeping or document management systems that are particularly useful in this space? Well, no is the honest answer, as in no specific recommendations. And again, so I've worked with some businesses where there are kind of IP, the specific IP management systems out there. I think they're not at all well suited to the startup and SME end of the marketplace. They're kind of they're expensive. They're too complicated. You know, they're aimed at big corporates or law firms that are managing portfolios of IP cases where they're kind of very date driven and all the rest of it. I think something fairly straightforward. So there's a business based locally to me, run by a guy who's ex Nokia, used to run Nokia's IP. He's started to produce and puts out basically Excel spreadsheet based, slightly fancy Excel spreadsheet based products for tracking IP risk for an IP asset register. But actually, a lot of the time, just a simple Excel spreadsheet is all you need at this stage. And again, I'd encourage, if you're already using, I don't know, Airtable or Monday, or if you're already using something as either a document repository or a place to capture these registers and other aspects around other aspects of your business, it's much better to try and integrate the IP aspects of that into your existing IT stack than it is to add yet another thing on, would be my view. And then in terms of document management and sort of looking after trade secrets, again, I think any of the, if you're using Google Documents or you're using Office 365 or you're using other existing document management platforms, they'll all have the facility to demark certain folders with permissions to say, only we'll give access to this folder on a need to know basis rather than to the whole organization. So any of those are adequate in terms of what the law requires, so long as you kind of manage them in the appropriate way and manage the permissions, and ideally have a kind of policy that underpins it, so a written policy that underpins it, that you can, so you can pull all of these things out if push came to shove and you had to prove to a court that this valuable algorithm was a trade secret and you looked after it. So IP strategy, so it sounds, I always think the word strategy sounds like it needs to be something complicated and involved, but the reality of it, I think, and sometimes I talk about IP plans rather than strategies, but really the reality of it is it's just defining and having a record of the when, why, what, who, where and how of all of the stuff we've just been talking about for the last hour and 20 minutes now. So that when you're faced with those decisions about, is it worth protecting this new bit of innovation, how are we going to protect it, where are we going to protect it, you're not having to reinvent the wheel every time. You've got your kind of model answer there, and yes, there's going to be exceptions, but basically you've got the answers to those questions, so that the answer in a particular case spits out without you having to apply lots of time and lots of brain power to it. You've got those model agreements that you'll have with different types of relationship. So you've got your model employment contract, you've got your model contractor contract that have all been reviewed and looked at, and that they're going to deal with the IP in a way, in an appropriate way. You've got in terms of going into new negotiations with a partner, you've maybe got an outline set of questions that include the appropriate questions about IP ownership, so that you're entering those new partnerships with the right mindset. And then the other thing I think to say about IP strategy is that it should never be a kind of done once type thing. You really need to be revisiting your strategy on a regular basis. Now, regular for a lot of businesses might be once a year, but particularly for sort of very early stage businesses that are where the business is evolving itself very rapidly, it might be you need to be looking at it and potentially reviewing it on a quarterly basis. Because again, it sort of we'll come back to where we started, which is that IP and IP strategy is really all about supporting the business to operate and grow in the way that they want to grow and they want to plan that they plan to grow. So it's all about it's in many ways IP strategy is an element of the overall business strategy. It shouldn't be something that's seen in isolation. It should be something that's kind of living, breathing, supports and is interwoven with the day-to-day operation of the business, so that by doing the right things at the right time, you put in place sound foundations and you avoid as many of the IP pitfalls as you can, so that when you come to significant events for your business, like they keep coming back to this, like fundraising, like sale or acquisition, you've got all the answers there already for the investor, for the potential acquirer. You've got that kind of strong, solid IP story that you can present to them, so that hopefully you just get a big tick in the IP box for the due diligence. Which is, again, being kind of frank and honest, IP is unlikely to be the most important thing to investors. Talking to investors in this sort of space, as you'd expect, it's the market opportunity, it's the team that are often the top two. But IP is significant, and it's not having the right IP approach and not protecting your IP in the right way is the sort of thing that will turn investors off who might otherwise have chosen to invest. And in some rare cases, it'll be the IP that they're interested in, and they will be genuinely investing in the IP. But often it's the IP that supports those other good things in the business. And then the final slide, or the final thing I was going to mention, and when we can kind of wrap up, is education. So, and I don't mean that everyone has to kind of go off and learn IP law and invest lots of time in this, but clearly, so I think everyone on this call has taken a good step in the right direction, because you're here and hopefully being educated about the relevance and the importance of IP and having the right kind of approach and mindset to IP in businesses in this space. But what I'd encourage is that those of you that are within organisations, talk to other people in the organisation about IP as well, because it's all very well having, let's say, an IP champion in the business that understands these things, but unless the people doing the innovation understand, for example, that it's super important to keep what they're doing secret until a decision has been made to release it. If when you get further down the line, businesses further down the line, they've got products on the market, often it's the salespeople, they get the first alarm bells ringing about potential competitors who might be infringing your IP, but also potential competitors who might have IP that you need to worry about. So having this basic level of education and understanding within the business as a whole as to not the ins and outs of how you get a patent and how you get a trademark, which I've sat through enough boring talks from other patent attorneys about that, but having a basic understanding of why IP is important to the business and the sorts of things they ought to be looking out for and the sorts of behaviours that they ought to be following, I think is super critical, because ultimately the business is its people, and if they aren't all pulling in the same direction in relation to the IP, then that's when the cracks start happening and the issues arise. So well, my hour turned into an hour and a half, but thank you for the questions along the way. So I think if it's all right with Rosie, what I'd suggest is we take like we're going to do 10 minutes, Rosie. Don't know if Rosie's name.
Yeah, 10 sounds good.
10 minutes, so you can check your emails, grab a coffee, whatever it is you want to do, and then we'll come back with an opportunity for more questions. So yeah, covering anything that we've talked about already, or if there's other burning IP related questions that you've got, feel free to throw anything at me and I'll try and answer them. And then once that bit comes to an end, we'll see if there's any willing volunteers for the live kind of clinic type sessions.
Just looking at the time, Stephen, how about we reconvene at 2:45?
Yep, sounds like a plan.
Great.
Right, so that's 10:45. So one of the problems with Zoom is you can't tell who's here and who's not. Hi, Holly.
Hi.
So, I can see Rosie there as well. It's fine. So I think we'll just assume people are back, and
Yeah.
feel free. I mean, at this stage, feel free. If you, I'm not going to present slides for this bit. So feel free to turn cameras on if you wish, but don't feel you have to. I didn't notice, Holly. But so yeah, feel free to turn cameras on if you want. It's always nice to see a few faces. And there's a couple of questions in chat that I didn't spot at the end just before I start talking, so I'll address those first. But if then anyone else has questions, if you either want to raise your hand, which will bring you, I think, to the top of the screen, or once we get to that point, just simply take yourself off mute and shout out, or by all means put more questions in the chat. So looking at the ones that were in the chat from before the break, Dennis asked, what are the limitations around self-service, especially patent searching versus paying a specialist, and what are the best publicly available resources? So I guess the thing with patent searching is there's a couple of things. One, the search or the results you get out of the search are only as good as the search criteria you put in. So for for the best results, you need to put the best criteria in. It's the old classic rubbish in, rubbish out. So a lot of the skill in patent searching is coming up with those search criteria in the first place. Now, some search criteria can be very simple, because you might just say, well, I want to see whether Hardian Health own any patents or have any patent applications. And you can put the name Hardian Health into a search search one of the free search resources, and it will return you a list of any records in that database that list Hardian Health as the proprietor of a published patent application or patent. So that's something else I guess I didn't mention as we went through, but it's probably worth noting, is that if we're talking about patent applications or patent publications, patents generally aren't published until 18 months after they're filed, or 18 months after their kind of earliest date they claim back to. So it means when you're patent searching, and this is one of the reasons why, particularly in those early stages, it's not, in my view, worth investing lots and lots of cash in extensive patent searches, because there's always this 18-month black hole in the results of the search, because you can't find stuff that hasn't been published. And particularly in sort of fast evolving, fast moving tech areas, a lot of the really juicy stuff is going to be in that 18-month black hole. So you can never do a completely comprehensive patent search. And anyone that tells you you can is lying. Particularly if they're trying to take lots of money off you for the privilege. So there's always going to be that period of uncertainty, which is also why, as I sort of think I alluded to earlier on, patent searching, like patent strategy, or as part of patent strategy, isn't a kind of shoot once and walk away type activity. It tends to be something that, again, you want to come back and revisit at certain stages in your product development. So I guess the biggest limitation of self-service patent searching is around coming up with appropriate search criteria. And in terms of patent searches, I mean, for certainly for the more complex patent searches, despite the experience I've got, I don't tend to do those myself. I outsource those to a specialist patent search firm, because basically they're spending all day, every day designing search strategies. And yes, I'll get them to share that strategy with me, so I can kind of satisfy myself that we're doing the right thing. But there is a kind of an art to it. But for some simple initial searching, and I guess it's one of those things where if you do some searching and you find some stuff, then that's useful for you. Yeah, you've got some results. If you do some searching and your searches don't find anything relevant, as a kind of self-service approach, it would probably be wrong to assume that means there's nothing out there. So I think particularly if you're interested in just seeing, what the competition are doing and getting some kind of flavour for what sorts of things people are filing patents for in your particular technology area, doing a bit of self-service searching certainly doesn't harm, and it can produce some interesting results for you. But we just need to accept it's never going to be comprehensive. And then in terms of the best publicly available resources, so Google Patents is pretty good these days. The other one that gets used most often probably is a service provided by the European Patent Office called Espasnet. I can circulate it, or I can give Rosie a link to circulate maybe in the email that she sends after the event. So hopefully that answers your question, Dennis, if you're still on the call. Oh yes, and he gave me a thumbs up. Perfect. So the next question was one from Emma. So it says, in research, we often have collaborators who share their data with us, and then we develop algorithms on this data with an aim potentially to make products in the future. Should IP agreements be included in data sharing agreements with collaborators? So yes, potentially. I mean, so in that scenario, the data, where the data is really, or might be the only IP asset that's that features in the shared arrangement, let's say. So the development of the algorithm is entirely in-house, so long as the data sharing agreement deals appropriately with clearly whatever issues there are around security of the data and all the usual kind of data sharing type issues, so long as it also addresses what use you're allowed to make of that data. So I've seen data sharing agreements in the past where, for example, the data is made available, but it's made available specifically for academic use. And if you take that data, and in your academic environment, you develop algorithms that produce some useful output. If you then spin that, let's say you're doing it within academia, if you spin that out into a new business and with a view to commercializing that algorithm, then you could get into arguments as to whether you're in breach of that original data agreement because you or you've used the data for something that ultimately has become a commercial use rather than. And so the sort of the devil's in the detail, but it's always important. And I was having this conversation just with a new university spin out just a couple of weeks back, where we're kind of digging back through the agreements that they've had in place, and in some cases potentially talking about renegotiating some of those agreements or deriving new data from other places. To the extent possible, you want a crystal ball gaze and say, you know, what is the goal? What do we want to use this data for? And just make sure that the agreement you have in place is sufficiently permissive to allow that. Without, the caveat to all of this is, you know, you could tie yourself up in knots, and never make any progress if you try and negotiate agreements that give you all of the freedom that you think you might need. So sometimes being pragmatic and just taking the next step forward is the better, the most appropriate thing to do. But to the extent possible, build in that, future-proof those agreements. Does that answer your point, Emma?
Yep, that answers my point. Thank you. Sorry, that was quite complicated.
No, it's fine. It's fine.
But, yeah, it's good. So what I've got from it is that, just making sure you've got those details in the agreement, but not wrapping yourself up into, putting yourself into a box too early. But it's really interesting topic. And so do you think the data sharing agreement should include something about the use of the data, what it's going to be used for generally in the future, and like if it's going to be used for research, and if that research would ever translate into a product? Is that kind of like what you should probably put in there?
Yeah, potentially. I guess the most important thing for you as the data recipient is to be very sure that there's no barriers to that in the agreement. So if the agreement explicitly says you can only use it for this, or you can only use it for these reasons, that's something that you might, one you need to be aware of, because you don't want to trip yourself up and misuse that data. But also it might be, particularly if you're in a position where you can negotiate the terms of the agreement, then that might be a point you want to negotiate, or at least kind of explore and understand what they mean by it. But some data sharing agreements or data access agreements, they're non-negotiable. You won't, there'll be standard terms from so biobank data. They typically have a standard agreement that you sign up to if you want access to that data, and you don't sign up to it if you don't, or if you don't sign up to it, you don't get access. But it's kind of is what it is. And it may be, I've seen some people take approaches where, at the very early stages of a business, you kind of need that data to start hypothesizing and developing algorithms and stuff. And you probably, you need to think carefully about where you take that data from, I guess. But sometimes, as I say, you just have to take the pragmatic approach, and you take the data from wherever it's available at an affordable cost and all the rest of it. But just have, and again, this is something that goes in your IP risk register if you have one of them, which is flagging that there are these limitations on the use you can make of the data. So you might get to a point where you sort of done your proof of concept to develop your algorithm, but when you're taking things further, maybe you need to switch data sources or look for other data, or I've talked to some people where they've got to a point and said, right, actually our plan going forward is we're going to start running our own trials and generating some of our own data that we know we can do what we want with. So it's just a lot of this IP stuff is just kind of being alive to the potential issues and thinking them through. And you know, there's always going to be some risk. Like in business generally, there's risks, aren't there? But it's just the better you can understand them and quantify them, the more likely you are to succeed, because you kind of address them at the point in time you need to address them.
Yeah. Okay, cool. Thank you so much.
No worries. And then Jackie. Jackie says, can you speak on use of unconsented health data to develop, e.g., algorithms and returns to the NHS when they are commercialised? Jackie, you on the call still?
Yep.
Hey. So again, I guess it depends. So using unconsented data, you're going to be governed by whatever data agreement you've got in place, from the source of that data. And so again, it's a bit like the conversation we just had. A lot of it will come down to what that agreement says you can and can't do with the data. When you're talking about returns to the NHS, what specifically was?
So benefits back to the NHS. So for instance, discounts or a revenue, arrangement, because the NHS has kind of curated the data and made it available. Yeah.
So again, I guess that's something that might be negotiated in the data agreement in the first place. So yeah, but I mean, the honest answer to your question is I've got no direct experience in that. But again, it's one of those things where it will come back to whether you're able to negotiate and just what those agreements say. What I have seen in the past is a kind of lack of uniformity across the different NHS trusts as a kind of what they're prepared to make available and what the terms might be. Hopefully that'll change as time goes forward.
Yeah, it's an interesting point for those of us who are involved in operating safe havens or trusted research environments. So I'm kind of on the other side of the fence, if you like.
Yeah, and it is interesting, and it's and clearly there's the technology is evolving as well, isn't it? In terms of there's models now where the data can actually stay in the protected environment, and you're just querying the data and you're getting the answers back out. And that's, we've seen more people talking about that over the last few years as a way of allowing this data to be used to progress science and hopefully deliver better patient benefit down the line, but whilst preserving the security of the data.
Yeah, but part of the way that we use unconsented data is we need to maintain the trust of the public that we're using their data. And if they see that particularly commercial companies are making huge profits as a result, then we're very aware of headlines that say NHS selling patient data, because we don't do that, but it's very easy for those headlines to appear and very, very difficult to refute.
Yeah, and I can see the issues there.
Okay, thank you.
No, you're welcome. You're welcome. So they were the questions that were in the chat. Are there any other questions that people want to ask? So again, either stick your hand up or just unmute yourself and shout out, or put a comment in the chat. Or have I answered all of the questions that are going on? Hugh's back. Another question.
Stephen, for the benefit of the audience, when do you advise that they start thinking about all of this stuff? And I'm talking about from day one, they come up with an idea. When, in your expert opinion, should people start thinking about this?
So my strong view is you really ought to be thinking about it from day one. That doesn't mean you need to start spending money on it from day one. But as soon as, basically, as soon as it's more than just one person sat in their bedroom you know, in their dressing gown like Holly, coming up with an idea. As soon as there's two people involved, and certainly as soon as there's kind of other organisations involved, you need to be, IP needs to be one of the things you're thinking about, because, you know, it's very easy to make mistakes, particularly around IP ownership at the outset, that you don't recognise, don't get uncovered until further down the line, and, you know, can be a really potentially massive obstacle to the success of the business. So thinking about it from really right from day one is important, and putting in place, even if it's just kind of an outline strategy, so initial thoughts about what the risks might be. So who, you know, there's some of this will be stuff that you're doing anyway when you're starting to map out your business plan, like who are the main competitors. So you can go a step further and say, who are the main competitors and do they have any patent applications pending? And then on the protection side of things, as I say, knowing or having the knowledge and the understanding that if patents are one of the things that might be relevant to your business, and for, you know, most businesses in the medtech space, they are potentially relevant, whether whether it's the right investment for your business at the appropriate time or not is a decision to be taken. But if they're potentially relevant, then having the right approach in place to keep your new innovation secret until, you know, to give yourself the chance to make that decision about whether you're going to patent or not, is super important. So, you know, and engaging with someone with the appropriate experience at an early stage to help with that initial planning, you know, can be a good thing, and probably certainly when you're at the stage of raising your first round of finance. So I mean, a lot of the grant funding that's available, so a lot of the Innovate UK grant funding that's available, you're allowed to put in allowances for IP work, IP advice. Certainly if you're raising money from, you know, seed money, I'd encourage businesses to have a budget in there for some initial IP work. So whether that might be filing their first patent application, which, you know, you're looking at 5 to 10K or something for that, or whether it's some initial kind of strategic advice, you know, having IP is one of the things on the radar that you ought to be building into budgets wherever possible, and including in fundraising. I think it'll do two things. One, it'll mean you can use that money to do the IP stuff and do it properly and put those really strong foundations in place. But two, I also think it sends a good, and this comes from conversations with investors as well, I think it sends a good message to investors that you're thinking about, if you like, being proprietorial about your technology that you're developing and looking after it in an appropriate way, because ultimately at the end of the day, that's you saying to them, we're going to look after the value in our business that you're investing in. So I've also heard from a couple of conversations with investors where maybe VCs are a little further down the line, when they look at a business, and yes, you know, they're super interested in the market opportunity and the technology and the product, super interested in the team. But if they start looking and they see that the business is taking a sound approach to IP, because it's one of the things that's very often overlooked, it's almost like a litmus test. You know, if the IP is being looked after well, it's very likely that all of the other stuff, or a lot of the other stuff, is going to be looked at. They're looking after that in an appropriate way as well. So,
and I got another follow-up question, which is the other end of the spectrum. At the end of all this, when we have a saturated market with multiple products all doing the same thing, and let's use an example that I'm very accustomed to, which is chest X-ray, AI. There's 20 companies all claiming to do the same thing. How does that market sort of shake out from an intellectual property point of view? Do they start suing each other, or what happens, and what's the sort of fallout from it?
Yeah, I mean, so it'll be interesting to see. Is the honest answer, and I think no one will know until it happens. But there are different models. You can look at yeah, so if, for example, you look at the pharma market, and I don't do pharma patents. Don't touch stuff that's wet or powdery, because I can draw hexagons, but I can't understand the long words they use in the pharma space. But if you look at the pharma market, yeah, they are generally quite litigious. They big pharma look to keep generics at bay with strong patent portfolios, and they're also quite acquisitive. So if people have if smaller businesses have a strong if they have a strong drug candidate and they have strong patent protection around that, then they often get gobbled up by one of the bigger players. So that's one way that you see kind of these IP markets shape themselves out, is through, I guess, primarily through acquisition. So that can be if as a small business, that can be one of your exit routes, and having a strong IP position can be the thing that sort of not necessarily forces that, but makes you more attractive for a potential acquirer. The other way you see them shaking out, so if you look at the telecoms industry, that tends to be an industry where there's a lot more cross-licensing of IP, and there the businesses tend to be building out their IP portfolios, because that's what gets them a seat at the negotiating table in terms of when these cross licenses are negotiated. And sort of taking that a step further, and what you also see in the telecom space, and actually it's kind of highly relevant to this digital health space as well, because obviously there's a lot of the innovation in digital health over the coming years is going to be driven by sort of Internet of Things and 5G connectivity and all the rest of it. And in a space like that, that's highly regulated in itself, the telecom space being regulated, there's sort of a forced license regime, if you like. So you have what they call standard essentials patents. So where if you have a patent that everyone in the space necessarily infringes because they need to operate in that way to satisfy the standard, then that's classed as a standard essential patent, and there's basically a sort of regulated patent licensing pool that all of those patents go into, and you still end up with arguments as to whether, or potential litigation. In fact, there's been some massive Nokia litigation over the last number of years around whether their patents were standard essential patents or not. But once your patent gets into that pool, you effectively get license fees at a fair rate from everyone operating in that space that needs to. So, I guess that I've not seen any talk about it yet, but I guess there's potential for that kind of thing. I mean, so certainly some of the sort of digital health operators will have to be buying into those 5G licenses and that type of thing, because they'll be necessarily operating within the scope of those patents. But that's I guess that's another way it shakes down, is through cross licensing or forced licensing type arrangements. And then the other way, I guess, is just the kind of hard-nosed patent litigation or threatened litigation, where businesses fail because they can't continue to commercialize their product, or they can't get their product to market because there's a big patent barrier in the way, and they can't negotiate an appropriate way forward with the patent owner. I suppose one thing might be worth mentioning around that is insurance. So it's possible to insure businesses against the costs of IP litigation. So you can take out a policy, both defensive and attack. And if you go back sort of 5 or 10 years, these policies were super expensive. The premium was really high, out of reach of SMEs. But that landscape, that insurance landscape has changed, and there's a broker that I work quite closely with, who's sort of works with the market, and they've got policies that are specifically aimed at the SME end of the market for IP insurance, and so much more reasonable premiums, and they basically cover the cost of defending yourself against an infringement claim, and also the cost of enforcing your own IP. And the bigger benefit of that, so you never want to go to court. You never want to have an IP battle in court, because it'll, it's to be avoided as at all costs, in my view, because it will absorb so much management time. They are costly. Even if you cover with insurance, you're still paying an element towards that. And but what having insurance does do is it levels the playing field. So if you have a big business, quite often they'll see the little business that owns a patent, and they go, well, we can just ignore that patent because they're small, they can never afford to enforce these patents anyway. But once they become aware that you've got insurance that's going to cover a large portion of the cost of the litigation, it changes that picture, and it's much more likely they're going to come to a negotiating table and you reach an appropriate deal. So yeah, and likewise, if it's the big company that has the patents, you will see bad players who will shout at you loudly to say you're infringing their rights, but actually they don't really have a strong case. But because you're a small player, they'll think, well, they're just going to give in and pay me a small license fee, or do something different. Whereas if you've got the insurance, it can levels that playing field. Yeah. Sorry, Ashley, I can see you've unmuted. Does that mean you got a question? No. So Ben has put a question in the chat, which is, are there any key examples of aspects or types of software which cannot be protected by IP? So I guess that we took a look at IP generally. So all newly created software code will attract copyright protection. So you'll always have that copyright there. Okay. Now, one of the things that people think about in that context is open source. So if you're taking software code from an open source library, then clearly that's not your original creation. So you don't have copyright in that that bit of code that you've taken from the library. But you've likely still got copyright in the overall body of code that you're creating with the bits that you're taking from other libraries. The thing to be most cautious about with open source is, so people think of open source software as being like IP right free. It's there to use as we choose. But actually, the way open source works is it is basically a copyright license. So copyright exists in that bit of open source code, and then what the open source library says, what the open source license says, is that you can use this code without making payment within the terms of this agreement. And there's anyone here working in the space will know that there's different libraries and there's different terms of using those libraries, and they're basically different copyright licenses. And you do have to be a bit cautious because some of the terms of those licenses can cause issues when you're looking to use the open source code for commercial purposes. So some of the more let's call them restrictive licenses will say, yes, you can use all this stuff for free, but only on the condition that whatever you generate using open source code from our library, you pass on in the same way. So you also make it freely available. And clearly that can be a big issue if what you're looking to do is make money out of the software that you're writing. And then if we look at patent protection, which is the other sort of key form of IP protection for software innovation, the way the law looks at it is it looks less at the actual kind of code and the structure and what's going on at that level. It's more about what's the software being used for, what's the end result of the software. And if the end result is in the sort of financial or business or kind of commerce world, so if what you end up at the end of the day is a better way to run your business, or I don't know, a better way of making investment decisions, or a better way, or an easier way of implementing the e-commerce aspects of your website, then that's going to be on the wrong side of the line for patents. Most jurisdictions around the world are going to say that that's not sufficiently technical. Whereas if what you have at the end of the day is a better medical device, or because it's being, because where the only thing that's changed is the software that's controlling that medical robot, let's say, you'll still be able to protect that software as kind of the new way of controlling the robot. If you've got something that gives you better resolution of radiographic images of some sort or another, then that's going to be considered technical. So it's the use to which the software is being put that's important, rather than characteristics of the software itself, if that makes sense. Does that answer your question, Ben?
Yeah, no, that's really helpful. Thank you.
Do we have any other questions? Cool. Well, if people think of questions after the event, then I'm sure we'll share in the email follow-up contact details for me and other relevant people at Hardian, I'm sure. So feel free to reach out. So the last bit that we were going to try and do, and we've got, so I think 12 o'clock is the sort of scheduled finish time of this. So we've got a bit of time left for those that are happy to hang around. So the plan was to run a kind of mini clinic session. So the idea being, if there's any willing volunteers who have a kind of product or a service, or they're developing, or they have in mind, and they're happy to share that in this public forum, and it doesn't have to be a lot of detail about it. Really, I guess it's an opportunity to talk to everyone on the call here about what it is you're trying to achieve, and then we can follow through at a high level the process that I mapped out. So we'll sort of we can have a little talk about where the value is. We can talk about what are the IP assets that underpin that are being generated or will be generated, and we can have a think about how the ownership structure might work, how what sort of risks you might want to be thinking about, and what the protection might look like. So if there are any volunteers for that, make yourself known now. If not, then what I might do, I think I won't fill the full 40 minutes with it, but I'll talk you through naming no names, a kind of example that I've been working on recently. But before I do that, do we have any volunteers? Stony silence.
I think, Stephen, it's probably best that you talk about your usual process, how you'd engage.
Yeah, no, I will. So in terms of, let's take an example of an app, and so I'm going to distort the detail a little bit. But let's talk. It's the other thing I say is that, so this is what I'm going to talk you through now, I suppose, is the initial kind of clinic type conversation that I might have with someone who has developed a new product, or is thinking about developing a new product, and wants to kind of do the right thing from the outset in terms of getting their IP house in order. So that's the kind of context of this. And if there's anyone that kind of wants to have one of those discussions, and I kind of appreciate having it in a big open forum like this is not always the best format to do it. So it doesn't necessarily surprise me that no one's putting their hand up for that. But if you want to have that kind of conversation, then by all means reach out to me. And I see Hugh's put my email in there in the chat, and you'll get that detail in the email follow-up as well. And yeah, and so we can have that kind of initial conversation. But let's take an example of an app that's looking at supporting people with mental health issues of one sort or another. And that app is going to deliver information to those people. It's going to deliver bespoke coaching to those people based on their interaction with the app, and also their other parameters, potentially, what they have in mind in the future. It's going to start to look at measuring people's stress levels with sensors they're wearing on their body. So that might be their smartwatch, it might be their phone, it might be their phone's listening the characteristics of their voice when they're speaking and detecting stress that way. So they have in mind that this might be the way the thing evolves. And they're doing this with a Innovate UK, let's say, grant funded project, where they're working with some academics that have a lot of experience in this space, in terms of understanding the relationship between the answers that users give to questionnaires and how to interpret those answers to measure a stress level and identify potential issues that need to be addressed. And then they're working with another organisation who run a team of people that offer support and advice and coaching to people that are suffering from a problem. So that's the kind of scenario that they've come to me with. And so the starting point would be talking with them and understanding what are the plans for the business, what's the business model in terms of how are they going to make money out of this. Are they looking to develop a platform and an app that's going to be self-serve for the user? Are they looking to develop a platform that's going to be used in a clinical situation as support for mental health clinicians? Is it going to be a bit of both? And what's the revenue stream going to be? Are they going to be so most likely in that kind of scenario, and probably the answer they would give is it's going to be an ongoing subscription model, maybe with an initial free version, and then 2 or 3 subscription levels with extra functionality built in. So where's the value? Well, the value is in the app. It's in the platform that supports the app, but it's also in the knowledge that's being embedded in that app. So there's the know-how that's going to that app. It's in the software code that is being written to implement the app. It's in the user interfaces, and it's downstream with what they have in mind. It's going to be in the technical development around the sensors and taking the sensor data, and then it's also going to be the data that's being collected, which they're going to use to improve and evolve the algorithms that they've started with to map the question answers onto the coaching and advice that the app's going to be giving. So that's kind of where the value is. and where the IP assets that underpin that value. So then the next question we'd moving on to sort of discuss at top level is around ownership and starting to map out the players who are involved. So in this scenario, so we've got the founders in the business, one of whom is a mental health clinician, one of whom is an app developer, and they kind of got their heads together. So actually the app code itself is being written by one of the founders, the initial iteration of it. And some of that knowledge, know-how is coming from the other co-founder. And that they come up with this idea and they've incorporated a company. So one of the first things we might look at is the timing of that. Did they incorporate the company before or after they started having their discussions and started putting down the first kind of iteration of the coding, the first iteration of the app? And if it turns out that they had the sort of first iterations of coding the app but before they'd incorporated the company, then one of the things you can do very quickly and easily at that point is, well, let's get all of those IP assets that you've already created into the business, because that's what even your first kind of angel investors are probably going to be looking for. So let's deal with that first. And then let's start to look at, so you're going to be working with academia to evolve these algorithms. So you need to start looking at what's the relationship going to be with the academics, and with, more importantly, I guess, with the academic institution, and make sure that as a business you understand whether you're going to be able to own those rights, whether that's going to be a license arrangement with the university in the first instance, which is quite often the case with academia. So particularly if sort of some of the core of the IP, and if, I guess part of that is helping you think about and decide what sort of relationship do you want to have with the academic institution. Now, if it's grant funded, then some of the parameters of that relationship might be forced upon you. If you've got funding from elsewhere, then it might be that you can have more of a kind of contract research relationship with the university, which makes it easier for your business to own all of the IP. If it's more of a grant funded collaboration, then it's more likely that the university will, at least initially, keep hold of ownership of some of the IP, and you want to make sure there's the right provisions for you to be able to license that from them at reasonable rates. So we look around those ownership issues, and then actually if you're then working with this other external business, to look at the designing of the questionnaire and the interpretation of the answers to that questionnaire. What's the relationship going to be with that business? Let's make sure you've got an agreement in place. And maybe, you know, sometimes that might be they're going to take a small equity stake in your business in exchange for their input, but you get to own the IP, or it might be they're reluctant to hand over their IP and you need some kind of license arrangement in place with them. So let's look around that ownership issue. And then we'd move on and we'd have a conversation about the risks, or a top level conversation about the risks. And let's understand what is the competitive landscape like? Do you have any idea what the competitive landscape is like? If not, maybe one of the first things we talk about doing is a kind of broad top level competitor landscape pattern search. If it's the sort of field that lends itself to that, because that can be quite useful in identifying who's active in the field, both at a company level and also at an individual inventor level. So it might even allow you to identify academics that you might choose to work with, or businesses that you could partner with, or established businesses where you want to avoid IP that they already have in place. And then the final, if you like, the icing on the cake, is we talk about protection. And for that kind of innovation, we'd probably be saying, right, well, early doors, when you're in the development phase, let's just keep everything wrapped up as trade secrets. So you're not having to spend too much money, you're just having to make sure you're following the right processes and you've got a good policy in place to look after these innovations as trade secrets. But let's have a regular cadence of meetings that consider the IP questions. So maybe that's, you know, in a monthly project meeting that's going on anyway. Let's just have one of the agenda items as, yeah, have we involved any other people in the project since last time? What agreements do we have in place? Have we, what are the latest iterations in the product? Is there anything new there that we want to capture on our IP asset register? And what decision are we going to make about protecting it? Is it still the case that we're just going to keep it secret for now? Ultimately, we're going to get to a point where we want to start releasing demo out to a test cohort. So how are we going to manage that? Let's look at having, is it realistic to have agreements in place with everyone in that test cohort? Or do we want to, do we take the commercial decision that we're not going to have, it's unrealistic to have agreements for that, and for that test cohort to keep everything confidential? So is this the tipping, are we at a tipping point where we need to think about filing a patent application? If there's something in the innovation at that point that we think can be patented. And then certainly when the sort of conversation around protection, when they start to talk about incorporating sensor data and potentially even developing or working with sensor manufacturers to produce something that's specific to their application, then definitely there'd be a conversation around patent protection there. So yeah, and then helping them map out, I guess, what that strategy should be. So that would be an initial conversation, and I guess it gives the business the framework that as time goes on and as budgets and funds become available, and I guess part of that exercise is budgeting. What would it cost to put in place the protection that we think we might need down the line, so we can build that into budgets. Yeah, so it gives them that framework that then, as they progress down the line, they can start filling out the details. So Marcus has popped a question into the chat, which is, if you're employed by a university but 100% of your salary is funded by someone else, e.g. Wellcome Trust or Eng, could you argue that the university has a lower share of your IP? So the answer is that will almost certainly be dealt with in, particularly if it's people like Eng or Wellcome Trust, that will be dealt with in the agreement between the university and those organisations as to where the IP ownership will lie, and what uses the different organisations can make with that IP. So well, both those organisations have standard templates that they'll typically put with at least the beginnings of negotiations. But it's a good example of how, like, the ownership, the whole ownership question isn't necessarily just a one-to-one or two-party question, because in a scenario like that, as an academic in the university or an employee of the university, there'll probably be some terms in your employment contract dealing with IP and ownership of IP, and the default is likely to be that the university will own it, or if there were no terms, that most likely be the default. And then you'll have agreements in place between the university and the funding bodies for particular projects, and they probably have some terms around IP, and you can end up in a position where there's conflicting terms, and that is, can be fun to sort out. But generally speaking, you can just sort of follow the flow of the IP ownership of the IP asset through from the actual originator, which is always like, it's always an individual, until you start talking about AI entities inventing stuff. That's a whole other topic. But yeah, you can follow the flow of the IP ownership through those agreements and work out in any one case where it ends up. And clearly the aim is, when you're setting up those agreements in the first place, or you're adding another agreement to the fold, is to engineer it in a way that gets the IP ownership where commercially you want it to be, if possible. Cool. Any more questions? Tristan.
I'm aware that this is a bit of a developing field and there probably isn't an easy answer, but in the context of adaptive algorithms using, say, public data in an NHS setting, and where increasingly it's kind of being recognized more that future iterations of those algorithms that have learned of public data somewhat have incorporated that data within their latest models. Where do you see IP for those algorithms in their kind of future models that have learned of the previous data? Where do you see IP falling on those?
It's that is an interesting question, and as you say, it's kind of an evolving field. I mean, the way the kind of IP framework and the laws work at the minute, it's still, you know, and a lesson until those change, it's still likely to be the case that the starting point will be the owner is the person who, if you like, created the algorithm in the first place and is kind of managing or, you know, allowing the ongoing evolution of that algorithm. And the fact that it's that some of the influence on the way that algorithm is evolving is coming from, you know, data that's being sourced from public sources. I don't think in the short term it's going to kind of change that starting assumption. Yeah, unless there's some kind of contractual arrangement in place that dictates a different arrangement. But yeah, it's an interesting area, and there's I think one argument is that if you like, the technology is evolving quicker than the IP law, and that's often the case. You know, technology takes leaps and bounds forwards, and IP law only catches up either when there's some court cases, so that the judges take a view as to how the existing law ought to be applied to those cases, or there's legislation changes because someone's recognised that the existing legislation just doesn't sit comfortably with where we are now in terms of the technology evolution, but they're quite few and far between. So it tends to be the evolution in the law tends to be through, certainly in this country, through the cases and how it's applied to the particular cases, and that's generally lags quite significantly behind the technology evolution, if that makes sense. So I don't know if that's really an answer or not, Tristan, but
no, it's just useful to kind of it was kind of what I was expecting, as you can tell from the question. But you know, whilst I've got the ear of an IP expert, it's just interesting to get a kind of what might be a more up-to-date perspective, or potentially where you see things moving. But yeah, another kind of TBC when it comes to these kind of novel algorithms.
Yeah, exactly. I mean, and I think the sort of, I guess the message there, the take-home message there is that to the extent you can dictate the IP aspects by agreement, then do that, and do it in a way that works for the parties that are involved, given their interests. Cool. So we've got a couple of people sloping off. Holly, what does Holly say? Really interesting about the lag. I wonder what needs to change culturally for us to take a more proactive approach. Yeah, I don't. That's another. Probably have a whole other big debate about that, Holly. But I mean, I think my view is that you kind of almost don't. You don't want the law to be changing and dictating and driving behavior in relation to sort of technology innovation, other than the very basic. I mean, yeah, fundamentally, the patent process is about driving a certain behavior in the innovation space, because the patent systems fundamentally are about encouraging people to publish information about what they're doing and how they're doing it, in exchange for potentially getting a 20-year monopoly in your innovation. But I think you can. My view is I think you can kind of tinker to. It's difficult to crystal ball gaze. None of us know where this technology evolution is going to take us, probably in the next 12 months, let alone the next 5 years. And if you try and crystal ball gaze with the legislation and the IP legislation in particular, you're almost certainly going to get it wrong, and then you're going to get the legislation potentially is going to distort the innovation or stifle the innovation. So I think it probably has to work in the way where the law lags behind. And some people would say, in a common law situation like we have in the UK, and the US is similar. One of the benefits of it is you have that kind of a bit more flexibility than you do in some of the continental legal systems, where the judges can factor in what's happened in the world since that legislation was put down on paper, and interpret it in a way that fits with the current models and the current things that are going on, we hope. Any final questions before I hand back to Rosie to wrap up? No, take that as a no. Hopefully Rosie's still there. Yes, yes.
Still here. Thank you, Stephen. I just wanted to say thank you so much for speaking today. I think that was really, really informative. And just to reiterate that we will share a recording after the event in the email, and it would be great to get some feedback from you all as well. So we'll put a survey in that email also. I'm just going to share a very, very quick slide with a few resources and other events coming up from the training team and from Hardian Health. So the next of the series of interactive webinars with Hardian Health is actually the same time next week, so 9 till 12, Thursday the 16th, and that's going to be on medical device regulations and quality management. And bookings for that are still open, so you'll be able to book through Eventbrite and attend that. We've also got some other live workshops coming up, which you can view on the main HGIK events page. For example, a health information engineering workshop. We have a monthly training newsletter, which you can scan the QR code beneath to sign up to, and that will keep you up to date with everything that we've got going on and coming up on the horizon. Similarly, you can follow us on LinkedIn and on Twitter. And finally, you can also sign up to our free virtual learning environment, Health Data Research Futures, and that's the bottom right-hand QR code. So I will just finish up by saying thank you very much for joining us today. Do drop us an email at learn@hdr.ac.uk if you have any questions. Sorry, that's learn@hdruk.ac.uk if you have any questions. And Stephen, if you have any last words before we end the call, do go ahead.
No, I mean, just thank you to everyone attending. Hopefully you've taken some useful learnings from there, and wish you all success in whatever it is you're going on to do.
Amazing. Thanks very much, Stephen, and thanks everyone again for joining. Have a lovely rest of the day.